2 hours.
Thank you, Chairman Carper, and thank you very much for holding this hearing. So giant corporations use bad trade deals to pad their profits and to chip away at protection for workers and for consumers. And now that the U.S. and other governments are trying to rein in big tech, their lobbyists and lawyers are trying to rig digital trade rules to undermine those new regulatory laws. They wrote some of the digital rules in the new NAFTA agreement, and now they're trying to rig the new Indo-Pacific Economic Framework negotiations as well. So take artificial intelligence, or AI. Companies increasingly rely on AI, even though AI, for example, can discriminate systematically, rejecting a job or loan for an applicant for having a black-sounding name, or penalizing a worker for a disability, or misidentifying women of color in police footage. This raises big concerns, and Congress and regulators are now taking a very close look at what's going on. But big tech wants to keep its code in a black box where nobody gets to look at it. Mr. Woodall, you're the policy director at the AFL-CIO Technology Institute. You are an expert on digital trade. Under the source code secrecy rules that big tech is now pushing as part of its digital trade agenda, could Congress pass pending legislation requiring that companies submit their AI code to the government or to third parties, say, to assess it for potential bias?
Senator, obviously Congress could pass those laws to address the discriminatory impacts of AI in the workplace, but they could run afoul of the digital trade rules and be vulnerable to a challenge or a trade dispute. Obviously, the reliance on this necessary and legitimate clause or justification would be, I think, a little thin reed to hide behind. That the question is legitimate to whom, necessary to whom, and recognizing that in the digital and technology world, our sort of regulatory landscape is very, very thin. Most of the other trade areas have been built were really the WTO went into effect decades after we had environmental protections and workplace safety rules. So this is a very different sort of environment where the digital trade has a different impact on the ability to address the known downsides of technology on workers and people.
Okay, so that is a really powerful point. Now, you know, tech lobbyists like to say that source code secrecy is about protecting trade secrets from China, but they have written the trade rules to apply to everyone, including U.S. regulators. Now, the tech lobbyists will say the language includes exceptions that ensure that regulators can still get access. So what I want to do is just take another closer look at the fine print on this. Regulators can look at source code or algorithms for, quote, a specific investigation, inspection, examination, enforcement action, or judicial proceeding. Mr. Woodall, could regulators really use this exception? Is this going to solve the problem?
I think it's a real concern, Senator. And the reason, there are a couple of reasons. One is that this sort of flags the VW problem, right? Where EPA got a whistleblower sent the source code to EPA that flagged that there was a problem with VW spoofing emissions tests. Now, the question is whether there would be an ability to pursue these kinds of investigations. It's really a chicken and egg problem, right? You have to know enough to be able to pursue the investigation. And so this specificity language could make it hard to really know whether to launch an investigation without being able to see under the hood. And then the second sort of problem with the specificity language is it pretty much precludes sector-wide or practice-wide investigations that regulators frequently pursue to see how consumers are protected or what's going on in the workplace. So I think that the recognition that there's a legitimate role for government is good, but the narrowing it to a very specific case really is a concern for us.
Okay, so I get your point. So big tech wants to protect whatever is in the black box from AI, and they not only want to protect it from China, they want to protect it from U.S. regulators. But of course, big tech companies only care about secrecy when it's their secrets that they want to protect. Meanwhile, they're fighting to protect their ability to collect, to store, and to sell your data anywhere else that they want in the world. And that's why the tech lobbyists behind the trade rules prohibit any limits on the international transfer of data. So what if we wanted here in the United States to put limits on the transfer of sensitive data, say period tracking data or location data for people who visited abortion clinics? Especially, we want to put limits to countries with poor data protections. Mr. Woodall, big tech says we shouldn't worry because countries can still pass laws to protect data so long as they fit under standard trade agreement language called the legitimate public policy exception. But how often have countries actually succeeded in using this language to defend their laws protecting consumers or workers or the environment?
It's quite infrequent. Less than 5% of the cases where at the WTO where regulations were challenged as illegal trade barriers were upheld under these necessary and legitimacy type tests. So it's very difficult to survive under these particular policy caveats. But as I said, I think it's going to be harder with digital because we have so little regulatory infrastructure and foundation upon which to defend the legitimacy and the necessity of the regulation. So as we're this is a world where we're just beginning to confront the concerns of this. And there are a bunch of laws being considered in Congress that would affect things like digital privacy and monopolistic platform practices that could run afoul of these digital trade rules. I would add on the privacy issues, the language in the USMCA specifically says it must be necessary and proportionate to the risk, which is sort of an even higher threshold to defend future privacy rules. So all of this, look, there's a good reason to consider protecting privacy and protecting the data that is behind privacy for things, as have been said on this panel already, on things like biometrics, on health data, on financial data. There are good reasons to exclude those kinds of personal data from the digital, from the free flow of data and data localization. And there are good reasons to exclude things like critical infrastructure has also been said today. So I think thinking about exceptions to these data provisions is essential going forwards.
Okay, so thank you. It's a very, very powerful point you make. We're barely at 5% success rate on trying to enforce the exceptions, and you're saying it would be even worse under the conditions if we go forward in the digital area here. You know, it is not a surprise that big tech is trying to weaponize digital trade rules. They know that the U.S. Congress is now considering bipartisan legislation to try to rein in big tech. So this is a move to fight back. And let's be blunt, big tech has a lot of friends. I've raised concerns about the revolving door between big tech and the agencies like the Commerce Department that are leading our digital trade negotiations. We can't let big tech hijack current trade negotiations like the Indo-Pacific Economic Framework. Voters want Congress to strengthen their digital rights, and our trade agenda must reflect that approach. Thank you very much, Mr. Chairman, and I appreciate your indulgence for the long questions and answers.
No, we're happy to welcome you and indulge you as much as you needed. That was great. Thanks for that exchange. Thank you for the enthusiasm you bring to these subjects, too.